Good morning. Thank you for your testimony today. I don't think anybody that I'm aware of is opposed to making sure we have clarity on actual emergency situations. But I think that a lot of the pro-life community is worried that when you start making exceptions, they'll become check boxes to just get around and get right back to elective abortion on demand. So as people who negotiated this bill, and I understand folks on sort of all sides of the spectrum were involved in working on the language, if you could tell me and the public who's listening what's in the bill that protects against that, and if you would start, I know you know the language of the bill, Lisa, better than the other folks, and the doctors can talk off of how you explain the law.
Sure. So the bill clarifies that the risk of death is one situation, and then it clarifies that the risk of bodily function is the other. Now, the medical board and the labor code define what major bodily function is. They include things like immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. Those are already existing in the law, so that defines what kind of a major bodily function is. What our bill does is bring it back to the physician to figure out in a timely manner, so imminence is no longer an issue, whether or not there's a risk to her or whether there's a risk to her major bodily function, as already defined in the law.
Right, but when abortion was legal, the abortionists were physicians. So what prevents just getting around the intent of the law by just having abortion on demand, them checking the box going, yes, the major bodily function could be at issue? And I'm sure, again, since everybody is in agreement on the bill, I'm sure it's in here. Can you explain what it is?
Okay, so first and foremost, 170A prohibits abortions in Texas, except in two cases: risk of death, substantial impairment of major bodily function. That is it. That is the law. Hospitals are not licensed abortion facilities. We are hospitals. We treat emergencies. We treat acute care. There's a chapter that had like that before Dobbs came down that was a regulation of abortion facilities, and hospitals were specifically exempted. And so if the only legal permissive, if you will, pregnancy terminations, a majority of those will be happening in hospitals. I think there is protection to the extent that if there is a medical emergency, as that is defined, in an unlicensed abortion facility, that is protected too, because we want to make sure that if someone starts bleeding out in a clinic, they can get the care that they need. I don't think there's anything in here that says an elective abortion where there's no risk of death, no risk of substantial impairment of major bodily function is present, that is allowed or prohibited. I don't think any physician would, in practicing in our hospitals would make that decision, nor would the hospitals have any policies that would allow that. We never did before.
Additionally, we don't change the law with respect to reporting. So anytime that there is a termination within the hospital setting, or they're still going to have to report it, they're going to still have to document it. So that is your catch-all to determine that there is a reasonable medical judgment that there's a problem of either death or serious bodily injury.
And I would presume if an off-site physician, not in the hospital, is suddenly reporting a whole lot of life-threatening cases, that would kind of tend to let the agency know something's going on.
Correct. The provisions in here about an unlicensed facility really is dealing with rural Texas. Obviously, we have a lot of places in Texas where you're more than 200 miles from a hospital. And so if you're bleeding out and you have the opportunity to go to a doctor's office or a clinic in a medical emergency, that just allowed them to take care of it.
And there's also a provision in one of the sections, I don't remember where it is, regarding the medical treatment, where we're clarifying that there's no requirement that you alter, delay, or withhold. There is another subsection in there that says, however, this section cannot be construed to allow for a prohibited abortion under Texas law.
Doctors?
Thank you for the question. We practice in this state. We love this state. We are citizens of this state. We respect the laws of this state. I cannot imagine a scenario where a physician, based on our high ethical and moral standards, would check a box just to enable their ability to not follow the law. And I can say that with confidence. Thank you.
I agree with what Dr. Silva has said. The phrase elective, especially that word elective abortion, has to be looked at, and this HB 44 maintains the current prohibitions against elective abortions. What we have talked about this morning and discussed this morning have no relationship to elective abortions.
Additionally, the criminal civil penalties and honestly the private right of action still remain intact if you're talking about an elective abortion. This bill doesn't protect them from that.
Yeah, I mean, the main goal is to prevent delay. That is an overarching theme of House Bill 44 and its Senate companion. By the clarity, by making sure that we outline what is not aiding and abetting, it is preventing delay. It's people don't have to stop and be afraid. That's what we're trying to do here.
Thank you.